When we think of the word migration, what comes up into our heads? Hard work, hard labor, far from home. And that's true. A big part of Indonesian migrants who go abroad do these types of work, these types of hard work that requires so much sacrifice and physical strength. And today, migration is a deeply gendered issue. In 2018, 70% of migrants who go abroad are women. And in 2024, that data stayed consistent. 66% of migrants who go abroad are in fact also women. And so we must ask ourselves, why do these data show these figures? Old paradigms of pull and push factors of poverty, of economic reasons, purely economic reasons, is outdated and really cannot encapsulate all of the issues. Instead, we have to look at it deeper. We have to look at the sociological context of our society. We have to ask the questions on why do women even go abroad in the first place? And when they go abroad, what type of work do they do? More often than not, it's not often by choice, but often by necessity, shaped by the patriarchal values that are in our society. And these questions have to get answered. So that's why in this video, we're going to interview real PMI workers to see their perspective and to get their take on the whole issue, and really evaluating it using the tools that are supposed to help them, the law. Do these laws that are already in place really take into account their issues, their perspective, and ultimately their side? Let's see.
Halo, nama saya Ipah, umur 37 tahun. Dulu saya pernah kerja di Taiwan jadi pengurus panti jompo yang ngurusin orang-orang tua. Dulu sebelum kerja di Taiwan gaji saya kecil, jadi nggak mencukupi untuk kebutuhan keluarga. Makanya saya memutuskan untuk pergi ke Taiwan.
Halo, namaku Siti, umurku 33 tahun. Aku pernah kerja di Hong Kong sebagai ART. Kerja di Hong Kong kemauan sendiri karena ekonomi kurang.
Waktu itu saya ke Taiwan ngikut tetangga saya. Jadi semuanya yang ngurusin dokumen-dokumennya dia. Saya cuma ngelampirin KTP sama kakak sama surat keterangan dari keluarga, izin dari keluarga sih. Untuk pelatihannya itu kalau nggak salah saya 6 bulan. Saya diajak ke Jakarta dulu untuk pelatihan, habis itu saya dikirim ke Taiwan.
Waktu pendaftaran saya kurang tahu, saya cuma nyerahin dokumen, kakak, KTP, surat izin keluarga, karena yang ngurus semua saudara.
Waktu saya nyampe di Taiwan, saya nginep dulu di penampungan, kalau nggak salah itu 2 hari. Selama di penampungan, saya ketemu sama orang. Setelah itu baru saya diajak buat panti jomponya.
Waktu nyampe ke sana, aku langsung ke majikan, diantarin sama saudara.
Terus waktu saya udah nyampe di tempat itu, ternyata job desk saya itu saya ngurusin orang tua yang sekitaran umur 70 tahun. Terus nyiapin makan mereka, vitamin mereka, sama nyuciin baju mereka. Saya juga kalau misalkan mau cuti atau sakit, biasanya sih yang penting saya tuh ada pemberitahuan di hari yang sama. Gaji saya terima setiap tanggal 25, itu kalau nggak salah udah dipotong sama agensi. Jadi saya menerimanya dari agensi, bukan dari panti jomponya langsung.
Selama aku di sana, aku kerjanya yang nyapu, yang ngepel, yang masak, sebagai ART. Kalau soal gaji tiap bulan, tapi ada potongannya dari PT.
ya namanya juga jauh dari keluarga, jauh dari rumah, pasti kangen, pasti pengen pulang. Cuman kan gimana ya, untuk memenuhi kebutuhan hidup tetap kita harus jalanin gitu. Ya nggak peduli pandangan orang lain seperti apa, yang penting kan orang tua keluarga itu hidup tentram dan aman.
Kalau keinginan pulang sih ada, pengen ketemu anak di kampung. Waktu ibu bilang pas saya ke luar negeri, takutnya perdagangan manusia.
From the interviews, we can see that most of the respondents only have a limited understanding of their rights as migrant workers, because they tend to focus only on their financial conditions without considering the extended risks that come with the job. This shows that protection is not just about having laws on paper, but also about whether those laws are actually known and understood by the people they are meant to protect. Law number 18 of 2017 on protection of Indonesian migrant workers recognizes domestic work or workers for individual employers and households as a sector which must be protected by the state. However, the law only provides protections on the rights and obligations of workers in a general sense, without considering the specific needs and challenges which may be faced in the women-dominated field of domestic work. As Wabilia Husna explains in her journal, Perlindungan Terhadap Hak-Hak Perempuan Pekerja Migran Indonesia dalam Undang-Undang Nomor 18 Tahun 2017, Perspective Feminism Legal Theory, this law still has important gaps, especially when we look at it from a feminist legal perspective. Article 6 of the law states that every migrant worker has the right to, among others, get a professional and humane service, as well as non-discriminative treatment before, during, and after working. Article 34 also mandates the government to provide social protection to migrant workers with an emphasis on women and children protection policy. However, there are no clear guidelines on what constitutes a non-discriminative treatment, nor any specific policies tailored towards women's rights.
The patriarchal system of society creates an expectation for women to perform domestic work, such as taking care of household chores. As a result, women are not exposed to other trades, marginalizing women from the industry sector. Women are further disadvantaged because of an unequal access to education. In families with limited economic resources, parents tend to prioritize boys' education, while girls are more likely to be taken out of school. This prevents women from escaping the cycle of poverty, as it leaves them with less choices when it comes to decent jobs. In search of better living conditions abroad, most women migrant workers still end up working in the domestic sector, as it is the only job available which meets the capabilities that they have. However, working abroad often comes with higher wages, making it seem like a better option than working locally. This is true to some extent, as migrant workers have more concrete procedural policies in place. However, as the interviewees mentioned, some obtain jobs through their neighbors or relatives who takes care of all the administrative requirements, not including the workers in the process. Although there exists the Ministry of Manpower Regulation number 2 of 2015 regarding the protection of domestic workers for domestic workers locally as well, the implementation is not as rigid as the implementation of the law on foreign migrant workers. Women in general are already prone to unequal power relations, but this is even more evident in cases of domestic work. Without the law to provide strict protection on the rights of women migrant workers, this power relation can easily be misused by employers. Although not always the case, women migrant workers, especially those in the domestic sector, are prone to be exploited and subject to arbitrary actions by their employers. An example, as experienced by the interviewee, is the deduction of wages to be paid to the agency. This is a common practice, yet it is actually a violation of Article 22 of the Ministry of Manpower Regulation. Wages given to workers should be paid in full without any deduction, and the agency fees are supposed to be obtained from the employer. Another interviewee mentioned that she does not know regarding her rights to obtain leaves, which should have been explained in the contract.
On the extreme end, women migrant workers might even be vulnerable to sexual violence. For example, women may experience sexual harassment or assault by her employer, or even end up in a commercial sex work against her will. As a result, she may face unwanted pregnancy, sexually transmitted infections, or deep psychological trauma while having very limited access to medical services and legal protection. Women have the right to be free from this kind of violence, yet this right is not clearly protected under the law. The law should have considered the right to sexual and reproductive health and explicitly included within the scope of protection in Article 6, as this is one of the most basic rights that women should have access to, as stated in the Convention on the Elimination of All Forms of Discrimination Against Women. Another issue is protection during the period of work. Article 21 of the Migrant Workers Law explains the forms of protection provided to migrant workers while they are working. These encompass monitoring and evaluating employers, job conditions, and facilitating the fulfillment of workers' rights. However, this protection is still very broad. As Husna points out, there is no clear attention to gender-specific risks. One simple but important example is whether migrant workers have access to a private and safe living space which adequately fulfills and protects their rights, including their rights to sexual and reproductive health. One way for women to be able to break away from this cycle is by obtaining proper education and training. This ensures women obtain equal access and opportunities to decent work and income. Efforts must be made to affirm women of their abilities, ensuring that women have access to self-improvement opportunities. This provides women the abilities to protect themselves, especially in regards to their rights. This should not only include training on work skills or foreign language abilities, but also education regarding the rights that women have, such as in regards to their sexual and reproductive rights, bodily autonomy, and ways to protect themselves from sexual crimes. This kind of education helps women understand their bodies, recognize abuse, and know what to do and where to seek help if something happens. This ensures the protection of women's safety, dignity, and well-being.
So guys, for the Indonesian woman, migration is often a choice within limits. Limits set by a gender norm, unequal access to education, or law promise protection but fail to fully deliver it. The law said migrant workers are protected, but protection is more than a word written on the paper. It is a knowledge, it is enforcement, it is a recognition of women's specific realities. This is not just a migration story, it is a call to revise the law and educate a woman about reality working abroad. So dignity does not depend on the distance, and then the protection does not stop at the border.